Thank you. The third time I'm speaking, I think you must be thinking that I'm here to wake man, to wake you up. After first coffee, before first coffee I spoke, then after lunch I spoke, and after third coffee I spoke. So when I speak, now I'm going to speak for only 3 minutes. What is the best way forward for Pakistan in the ADR? By looking at litigation, which is very lengthy, and they don't have a confidence on litigation of the courts, what are the other methods the courts have done to do as an ADR, and which is the most effective way by looking at the legal anthropology and the anthology of the jurisprudence in Pakistan to see which is a best effective way, which at the end I will explain that mediation is a way forward. Sindh High Court, as I said, has done this thing with having everybody together with the Chief Justice permission, vision for everyone who are the main stakeholders and who are going to have the mediation. First is the ADR is arbitration. Unfortunately, by speaking and giving the first arbitration bill last week, I had to speak and I did research, and the arbitration has not been effective in Pakistan. Various cases have been pending in Pakistan because of what? The more interference by courts, lengthy procedure. It takes 1,118 days for the World Bank report for an arbitration in Pakistan. And unfortunately, when I look at the legal anthology of the case law under Pakistani Arbitration Act in 1940, which is 84 years old now, and Pakistan is the last country in the world to continue with 1940 Act. India got rid of in 1996 the new law. Pakistan, now thinking with the law they drafted and handed over to the law minister and the finance minister that day, has only, how many cases you think was passed? I passed a case yesterday, I gave another judgment, but how many cases have been passed in the last 84 years under the Arbitration Act 1940? Who heard me at IBA, don't raise hands. Who heard me at Islamabad and FGA, don't raise hands. How many do you think are cases decided under the 1940 Act? Whether it is a developed law or not a developed law? Raise hands. Any guess? Arbitration is the main backbone of Pakistan. Any guess from any? कितने केस डिसाइड होंगे 1940 के लॉ में पाकिस्तान में? Jurisprudence कितने केसों की होगी? Any idea? शफी साहब कह रहे हैं 80. Any idea of how many judgments have been passed by our courts in the last 84 years on a very important law? 80. He said 80. Wild guess. Only 42, and yesterday I gave a judgment on stepping into the arbitration proceeding. I'm counting 2 because of the division bench. Justice Mansoori Shah's judgment of NHA versus Sambu Construction, 2023 SCMR 1103. At the end, Justice Shah said they need to have a law for Pakistan because this law has clogged the artery of the justice in Pakistan. And it took an award for 14 years not enforced. That I opened our eyes. My question to you, that then once the arbitration law is not effective, it is lengthy, it has interference, then what is the second mode in the ADR? First is the arbitration, not effective, not used. No one has been successfully happy about that. Second is the mediation. Before that, another one, foreign arbitration award. Foreign awards are implemented hurriedly. Because another good news for Pakistan is bringing an arbitration act. Foreign Award Act, which is an ordinance, was drafted by Mr. Makhdoom Ali Khan, barrister, who was the Attorney General. And he drafted that law in 2006, became an act. Those judgments are now very much enforced by the courts. Sindh High Court first, Lahore High Court, now Supreme Court has given 2 judgments. And the third is, and the most effective is ENE, Early Neutral Party Evaluation. That could be mediation, or that could be settlement, that could be reconciliation. There's 3 ways. And the best way to do that in mediation would be approach, and now high time to convince parties for consent. 15 years ago, we started this whole process. Every law has this process. We tested this concept. You don't need to ask them. You have to direct them. Say, go back and think about an early neutral party version, whether you want a settlement, some go and settle a case. And I must acknowledge that we are taking credit as the commercial lawyer. We must give credit to judges who are doing lots of cases under the CRPC. Every day, judges hearing cases in the Sindh High Court, Supreme Court, Lahore High Court benches. So many mediation they do orally. Okay, why don't you pay this amount? We will bury you. There are a lot of, mediation is a very soft way. It's something, a kind of a settlement. That is to be counted to. If they don't write a judgment on that, but still it's a kind of a way in CRPC, every day there is something, a kind of a mediation happens in the court. And it's to be noted now. We are doing those kind of things. Nobody looks into that way, that CRPC has more cases than as CPC cases. And the last would be, is the ecosystem to develop is that under Order 9 and a Section 89 CPC, there is provision for asking the parties to go and settle amount. Now, we can invoke that with the basis of the judgment I gave earlier on, the Supreme Court judgment, the judgments of the Sindh High Court and other judgments, and now it could be a new dimension, a fast track. I look at a half glass full, half glass empty. I will see Pakistan is now in a domain where judges are sitting and going forward for mediation. And yesterday, I was giving a judgment before coming to this conference on developing a concept of strengthening the ecosystem, a case of a judge dismissed the Section 34 application by only stating that you step into proceeding by requesting the court to ask for filing the written statement. I examined the case carefully. They did not file any document. They did not take any adjournment like that. It was a routine adjournment. And the test, which I laid down yesterday, was the Supreme Court principles settled by a PIA case of 81 Supreme Court, where that by merely asking for a man, this is the concept. This is how the concept in Pakistan will be built, because there is no oral arbitration. Arbitration has to be given in express provision. That's what the new section is. And that's what the Lahore High Court in a judgment said. You cannot appoint arbitrator orally. So mediation is a very flexible thing. Mediation is kind of a settlement. Mediation is the part cases in your hand. And there's a new concept of Pakistan agenda today is a hashtag is say no to litigation, semicolon, say no to arbitration, semicolon, say yes to mediation. A new theme for Pakistan, inshallah. Thank you.